Pulse chain.
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 So this is Court Listener. If you've never seen this before, it's a free law project. A little bit more about Court Listener. It is a free legal research website containing millions of legal opinions from federal and state courts. With Court Listener, lawyers, journalists, academics, and the public can research an important case, stay up to date with new opinions as they're filed, or do a deep analysis using the raw data. So that's basically what it is, free to use for everyone. And now this is the case here that we know is going on, which is the SEC versus Richard Hart, aka Schuler. And now you can see here some of the main details about the case, as well as this part here, which is the important part, which is the timeline of events so far. So as you see, this is when it first all kicked off. It was July last year when the complaint was made. And these are all the old documents. We're not going to go through that because we've seen all that stuff before, and there's a lot of stuff there to go through. So if we jump there, you can see all of these 31st July, and it goes to August. So this is all the stuff we know already. And then here are the jumps now. So there was a summons there. Plaintiff is directed to file proof of service no later than November 21. So we know about this. They were looking for Richard Hart. We heard in Finland, and that was last month when this part came out. Notice of service. So I think we went through this, or I think this is quite known now to the community. But this is the important part that I want to go through here, which is what has just dropped. Yes, it'll be yesterday now here in the UK, or it will be still today on the 9th if you're in the States. Now, so this document here is the main document, and it's not too long. It's only 4 pages, so we'll go through all of it. Securities and Exchange Commission versus Schuler, letter document 13, and the first page is not too heavy. Let's go through that. So this is just addressing the Honourable Carol Bagley Amon. So this is for the District Court, Securities and Exchange Commission. Dear Judge Anon, now we represent defendant Richard J. Schuler, who goes by the name of Richard Hart, and submit this letter pursuant to Rule 3A of the Court's individual motion practices and rules to respectfully request a pre-motion conference and to provide summary of the basis of Mr. Hart's anticipated motion to dismiss the Securities and Exchange Commission's complaint. Interesting there. So he's making a statement to dismiss. Now he says, blockchains are the world's first and only immutable digital public ledgers, publishing messages, literature, art, commerce, computer code, and more. Richard Hart is an innovator in the blockchain communications technology who has been interested in its ability to benefit society since he first learned about Bitcoin in 2011. Now, the complaint alleges that Mr. Hart developed 3 open source blockchains communications software programs. So these are Hex, PulseChain, and PulseX. The complaint alleges that Mr. Hart and somehow the programs themselves violated the federal securities law by so-called crypto asset securities and purportedly misusing about 3% of the offering's proceeds associated with one of the 3 software programs. So you can see the amount they're pursuing here. It's absolutely tiny, so it's a bit of a joke here. This litigation is just the first. It's another front in the SEC's campaign to regulate blockchain technology and digital assets through enforcement instead of rulemaking or awaiting legislation. Its efforts particularly misguided in this case, where the complaint attacks certain blockchain software programs running on a decentralized ecosystem of computers across the world. There is no business, corporation, enterprise, or foundation behind them. Rather, a global community of individuals have independently chosen to run these communication software programs using their own labor and computing power, bearing individually the risks and rewards of doing so. Yeah. So for Hex, you mint your own coins. There's no expectation from the work of others. Mr. Hart, exercising his constitutional rights to free speech and association, has spoken in favour of these and other communication software programs. He has also extensively described their limitations, risks and downsides, which the complaints casts aside as its cherry-pick sound bites from hundreds of hours of Mr. Hart's wide-ranging public commentary. For the reasons set forth below, as will be detailed in Mr. Hart's anticipated motion, the complaint is without merit and warrants dismissal without prejudice. So in the notes part here, he's got naming hex, pulse and pulse chain, the pulse hex and pulse chain, alter ego defendants is truly bizarre. Under the SEC's own definitions, there are digital asset token and two software protocols. How software protocols can be entities subject to suit defies logic and precedent. There is no factual basis in the complaints for calling them Mr. Hart's alter egos, and the SEC's doing so is an affront to the vibrant community that runs them. The non-existence of these entities aside, the complaint lacks merit against them too. Right, so we'll move on to page 2 now. Let's just see how much this is. So yeah, this part here we don't really need to look at, so it's just a little bit more. Page 2 here. And the complaint fails to establish personal jurisdiction and was not properly served. The court should dismiss the complaint under Rule 12b2 because it fails to plead that Mr. Hart, who has not lived in or done business in the United States for well over a decade, has a connection with the United States such that he should reasonably anticipate being hailed into court there. Worldwide Volkswagen Corp. So this is a past case he's using as a precedent. It pleads no US-based entities and employees, contracts, payments account, marketing efforts or travel. The complaint merely asserts that an unspecified member of US residents engaged in transactions and that Mr. Hart discussed the software on social media. That does not approach what is necessary. Contacts with the defendant created within the forum rather than with persons who reside there. So he's quoting a few more cases here. Let's just skip through that. Nor does the website at issue alleged to have conducted registrations, taken user information, processed payments, or expressly aimed themselves at the United States. So there's more cases here. So it looks like he's got a lot of backup evidence there. The court should also dismiss the complaint under Rule 12b5, because dropping papers at the Finnish police station is not valid service. So yeah, so he hasn't been served. So it looks like they couldn't find him there, and they've dropped that at the police station because they did show his address in a previous correspondence, which we looked at on the map. The complaint suffers from a myriad pleading constitutional, statutory and regulatory deficiencies that mandate dismissal under Rule 12b6. First, the complaints fail because none of the transactions at issue are adequately alleged to have occurred in the United States, making the SEC's claim impossibly extraterrestrial. See Morrison versus Australian Bank. To establish domesticity, the SEC must allege details showing with respect to each of the wrongful transactions the title was transferred or irrevocably liability was incurred within the United States. It's another case there. A conclusory assertion that the securities transaction took place. So he's saying how can you prove that it took place in the States? Here the complaint does even less, alleging that they were only investors in the United States. This is not nearly enough, as the purchaser's citizenship or residency does not affect where the transaction occurs. So he's got lots of cases there. So these guys are really well researched here. Lots of cases as precedents to use. Secondly, the complaint fails to allege facts that could support the conclusion that Hex, Pulse Chain or Pulse X are investment contracts and therefore subject to federal securities laws. The complaint lacks a single allegation of any contract involving Mr. Hart or anyone, let alone an investment contract. Without that, the complaint does not plausibly allege the existence of any security. A host of other failures to plead an investment contract also warrant dismissal, also, as will be explained in Mr. Hart's motion. Third, the complaint fails to plead fraud with the particularly Rule 9b requires. There are no misstatements or omissions alleged, let alone any that are material, nor is a scienter sufficiently pleaded. Indeed, the complaint identifies no deceptive statement or conduct at all. So this is the final part here. So he's used another case there. It offers a conclusory assertion that individuals had a reasonable expectation about how alleged pulse chain assets would be used, despite being explicitly promised nothing. That does not plead deception, let alone support a strong inference of fraudulent intent. More cases there he's using as example. Seeing as pulse chain was developed and did launch, the securities fraud claim boils down to the SEC's disagreement on how 3% of pulse chain's alleged assets were purportedly used, an issue falling squarely outside the federal security laws. Another case there. Fourth, the court should dismiss the complaint because the SEC runs afoul of the major questions doctrine by way of this action. Executive agencies have only the powers specifically granted by them to them by Congress. They cannot undertake transformative expansion in authority without clear congressional authorization. That's another case there. Here and elsewhere, the SEC seeks to impose its will on the 2 trillion digital assets industry, but recent legislative proposals make clear that the Congress has not delegated authority over these digital assets to the SEC. To the contrary, the industry's regulation remains the subject of earnest and profound debate. West Virginia, another case there. Rather than follow the political process or even engage in rulemaking, the SEC seeks to press forward with regulation by enforcement. The court should halt that effort and dismiss the complaint for exceeding the SEC's lawful authority, consistent with a recent Supreme Court precedent. So I'm not sure if that maybe is the case of XRP or something like that. Fifth, the court should dismiss the complaint as it is unconstitutionally infringes on the freedoms of speech and association guaranteed by the First Amendment for Richard Hart and those who run Hex, PulseChain and PulseX software. The complaint seeks to impose a content-based regulation of computer code which constitutes protected speech. More cases there. The SEC's effort to hold the express conduct and association of individuals who believe that free speech is a protected human right and blockchains are free speech. More cases there. The complaint seeks to punish Mr. Hart for discussing open source peer-to-peer communications software, and because blockchains require trading tokens for space in their public ledgers, treating blockchains and their tokens as securities, which are banned from common trade and use as currencies, amount to a de facto ban on the world's first and only public immutable speech technology. Such a broad and harsh form of prior restraint imperceptibly chills free speech. And the last bit here is Mr. Hart intends to move to dismiss the complaint for the foregoing reasons and potentially others. The parties have met and confirmed and jointly request the following briefing schedule. Motion due on April the 8th, so that's 90 days after this letter. SEC response due July 8th, 2024. Reply due August 22nd, 2024. Mr. Hart respectfully requests the court schedule a pre-motion conference and approve the proposed briefing schedule. So, interesting. There's a full, comprehensive, legal, formal reply from Richard Hart's team, which is quite a big team. There's looks like 4 different companies involved here, and he's put forward a good case there. So we're going to see how this one plans out. So the next part is happening in April. Well, that's if they agree to this. So we'll keep you updated on what's happening with this case.